Hello there, everyone. My name is Kim McGarry, and I'm going to share the due process hearing that I recently did for this assignment. And it's titled Parent versus SAD number 75, and it took place in March of 2016. A few of the facts with this case is that this case dealt with a young man who attended school in SAD number 75, who received special education services under the categories of autism and intellectual disability. And this young man had been in this district for 12 years. He loved going to school, looked forward to going to school, never had any issues, and the staff at the district enjoyed working with him a great deal. Now, this student had very limited ability to communicate, and therefore the district and the parents had developed various ways over the years to share information and communicate daily about his days at school and his experiences with his programming. And this is something that has taken place right from the beginning of when he started with the district. This information has always gone back and forth. And although the district maintained this daily communication with the parents, for some reason, the parents started to become very dissatisfied with particular staff in general, and the relationship between the parents and the district grew very tense. There were a lot of allegations made against the district by the parents, and some of those are listed right here, as you can see, and we'll go into further detail with those as I continue through the slides. It was also alleged at one point, right before this went to court, that the mother had been showing up unannounced during field trips and when staff and students were out and about in the community and so on and so forth. And the district actually had teachers and support staff filing grievances, seeking medical attention to help with the stress that they were under, and actually had staff resign due to the hostile working environment that the parents were causing. Now, the district suggested on various occasions that they get together and meet as an IEP team to discuss various matters, but the parents declined on most occasions. And we're going to find out, did the district violate any state or federal special education laws? In the next slide I have listed are the issues, which basically are the allegations that was brought against the district. And those are all listed right out in order of how I read and that they were dealt with during the hearing. The holding here basically states, in a nutshell, if you read down through these, that the district was not found to be in violation whatsoever with any of those. Under the rationale, I've done the slides here to deal with each of the allegations separately. The first one was, did the district violate state or federal special ed law by failing to provide post-secondary transition planning? Now, the district was very prepared to move on with transition planning at the IEP meeting, but the parents were not ready to do so, so this did not take place. An agreement was made to not develop the transition plan for another year. The district had even invited other folks to come in to talk with what was going to take place, but this didn't happen because the parents just didn't want it to take place. There's a couple of different other cases here that took place previously that I've mentioned that kind of relate to this case. And you'll see at the bottom that it says that there was no evidence to support that the student had been deprived of educational opportunities because the parents were the ones that put a stop to the transition plan. So there is no FAPE violation. Number 2, did the district fail to complete a timely annual review of the student's IEP? No, they did not, and I've learned reading down through with the discussion and whatnot, the district initially held 2 such meetings. The parents, when they did attend an IEP meeting, their focus was basically on the litigation with the district. So very little time was spent discussing any academic goals or any goals to move on. The district attempted to schedule another IEP meeting to finish the process, but the parents were unwilling to meet again. Even though the parents were unwilling to meet, the district did go ahead and continue to do what they needed to do for the student. That his programs were continued, his educational programming and services under his IEP were followed as they always had been. So the parents' unreasonable behavior caused this failure to complete a new IEP in a timely manner. So there is no violation found in this particular case either. Number 3, did the district violate the IDEA by failing to provide documents related to autism consultation services? I learned reading down through this case that separate reports of consultation are not required. The IDEA does not require the district to prepare and maintain certain records. However, the district did, to accommodate the parents' request, keep records on an ongoing basis of when services were taking place and how often, by whom they did provide at the parents' request these records. And so there was no failure to provide requested records. There is no violation of the IDEA here either. Number 4, did the district's action in not permitting the student to wear a recording device while at school deprive the parent of any rights whatsoever in the decision-making process and his son's education? And I'll mention here that the parents had requested and sent letters to the school and called the school saying that they were going to send their son to school wearing a recording device on a daily basis, so they knew what happened throughout his entire day. This was not something that was favored by anybody else except for the parents. Professionals felt that they would not be able to do their jobs properly and comfortably. They didn't feel that the student himself would be comfortable and wouldn't act like himself. They felt that the parents were merely just trying to perhaps catch teachers, staff of any sort of maybe doing something they didn't like. It was not recommended. In other words, it was not recommended by the hearing officer in this case as well. She concluded that allowing the student to wear the device would actually interfere with his ability to receive education and that there would be no benefit whatsoever. And considering that the school gave the parents information on a daily basis about how his school day went, this was found to be of no benefit. So the parent had failed to provide evidence that the student is not receiving the appropriate education that he was supposed to, so no violations were found there either. Number 6, did the district violate state or federal special ed laws by failing to provide the student with autism consultation services? Now, according to the Muser definition that I read looking through this case and also in the Muser packet, and reading about the hearing officer's previous experience, consultation services are provided to assist direct service providers in doing a better job and taking what they've learned to provide high quality services and education to the students. It is not defined to mean providing services directly to students. The parents suspected that services were not being provided to their son under the IEP simply because of the allegations that they had been making and because certain staff members had filed grievances. But that was not found to be the case. The student's IEP was indeed being followed. He was receiving services as often as he was supposed to, when he was supposed to, and by whom, and therefore no violations were found to take place here. Number 7, does the IDEA require the district to provide the father, upon demand, with the names of those educators who filed grievances and who participated in a union grievance over 2 years ago? The biggest information that I took away from reading through this and learning about it was simply what I have typed here. When weighing the importance of honoring the confidentiality of teachers and ed techs under their respective collective bargaining agreements, it was found that this would not be an appropriate measure and that there was no compelling reason to require the identification of the grievance. Therefore, the hearing officer denied this request and dismissed this allegation. Number 8 simply says if the hearing officer finds a violation of applicable special education law, what remedies, if any, are appropriate? Well, there were no violations of the IDEA found, so there are no remedies necessary in this particular case. Now, reading through this case and reading the different pieces of information and the facts and the findings and the different discussion things that go on, we every day in our educational careers, we face daily opportunities where decisions need to be made and problems need to be handled, whether small or big. And life requires a lot of thinking ahead, planning, and problem solving, as I've written here. Is certainly for those of us that work within the schools, it's a critical aspect of our daily lives. We always have to be planning, looking ahead, thinking ahead, and handling things, especially when it comes to planning, writing, and following our students' IEPs. This is something that requires a true team effort to make sure that our students' needs are being met and the IEPs are being followed. And we're putting the student first. His needs come first and foremost. And it only takes one person to not be on board with the rest of the team and everyone else, and not wanting to work together to create this tense, toxic environment for everyone. Now, in this particular case, it was alleged that the mom was showing up unannounced and spying on field trip activities. Was this the case? Or was she truthfully just caught behind the bus on her way to the grocery store, as she had told the school members that that's what had taken place? Was it the accusation that she was spying that maybe started more dissatisfaction with staff members in the district? The student, again, had attended school in this district for 12 years and had done so successfully and was a very happy student. And the father's testimony even states that this was to be the case. And there was only maybe ever 3 or 4 days when the student ever came home that I found in reading through this case where he might have been a little off, from his normal self with no really big issues. Now, as school employees, what can we do to ensure a true team approach for meeting our students' needs? A genuine relationship with parents is definitely an important thing, as well as maintaining communication with them. Perhaps the parents are nervous about their son getting older and aren't ready to face what's next as far as the transition planning. It's hard to say. We have no way of knowing every detail about these people. I wasn't there. I don't know the people. I can only speculate. But I do know that a positive, caring team approach is what works best in meeting the needs of our students. And this is the one thing that we can always take with us. So I'm hoping now that the district was not found to be in violation of any of the state or federal special ed laws or the IDEA or any of those sorts of things. And so hopefully here on out, everyone on the IEP team will move forward. The transition planning will take effect, and this young man will have a bright, successful future. And I hope that in working with students in my capacity, that this is something that I don't ever have to deal with and face in the future, for sure. Thank you for listening to a little bit about the case. I know it's a very quick, brief rundown, and I feel like I've missed a lot of important things probably, but thank you for listening. Feel free to look through the slides at the information. And again, thank you very much.